Good morning and welcome to an oral argument session of the 5th District Court of Appeal. I'm Judge Orfinger and I'm joined on the panel today by Judge Meredith Sasso, and we have a visiting judge that we're honored to have, Judge Donna McIntosh, visiting with us. Both sides will have 20 minutes. The appellant can reserve as much time as he or she chooses. It's set for 5 minutes, but if you want something other than that, let me know and I'll try to alert you. This is being recorded and broadcast on YouTube.
And Judge, I can only see you. Am I supposed to be able to see the entire panel?
Click on the button. It should be in the left-hand corner of your screen that says switch to gallery view. There should be something that says switch to gallery view. You got that? Yes,
Your Honor. I'm an idiot when it comes to this stuff.
We're all learning as we go. All right, well, with that, we'll go ahead. This is the case of Napolitano versus St. Joseph Catholic Church and others. So, Mr. Benitez, whenever you'd like to start.
Yes, Your Honor, and I would like to reserve 5 minutes if I could, or whatever I have left. Judge, this is a case involving a motion to if it pleases the court, this is a case involving a motion to dismiss on subject matter jurisdiction. And what the court did is basically decide that there was one secular issue, that is whether there was authority by the pastor, Father Brown, to have entered into an employment contract. And based on his belief that he could not get into the structure, the organizational structure, or role of a pastor, he decided not to, he found that he basically didn't have subject matter jurisdiction. We have appealed the case based on the motion to dismiss, not having been granted an evidentiary hearing because there was opposing evidentiary matter submitted to the court. But then again,
the court considered, as I understand it, numerous affidavits and numerous citations of canon law. What other evidence would there have been? It seems to me the court considered a lot of evidence, although perhaps not live testimony. What evidence did you want to submit that you weren't given the opportunity to do so?
Well, Your Honor, I disagree. I don't believe he considered any of the evidence. I believe he just made a determination that he could not deal with the issue of authority or non-authority of Father Brown, the apparent or actual authority. So he basically didn't get into that issue, regardless of what he was submitted and regardless of what he might have read in reaching that opinion. His opinion was basically, I cannot delve into apparent or actual authority, and therefore I'm going to deny subject matter jurisdiction. That is based on the issue that was raised by the appellees in this case, which is basically that they have an issue with the authority of Father Brown. It is the church coming up with a question about the authority of a pastor within their organization, which is not a question, Judge, it's a fact. It's something that can be easily established, and I believe we established it below, and I think is somewhat lacking credibility that they're making an issue in this case.
Going to your point about what the trial court considered or did not consider, couldn't we, if we agreed with the trial court's conclusion, affirm on the basis of this record and de novo review, even if we disagreed with the exact method that the trial court used for coming to that conclusion, both considering the de novo standard and tipsy coachman, of course?
Yes, Your Honor. Yes, we are in de novo review. So in fact, you could consider the record in a sense, but Judge, in this case, I mean, the court was very specific with respect to its ruling, and its ruling is we cannot go and deal with the apparent authority or actual authority. And you've got to remember what they did is they brought that issue up before a responsive pleading has been filed. At the stage of a motion to dismiss, they basically said, we're going to contest the authority. So what they basically did is establish immunity from this kind of civil litigation de facto by simply contesting a known fact within the Catholic Church that in fact the pastor.
Well, you could characterize it as immunity, but you could also characterize it as an initial determination as to whether courts are authorized, whether secular courts are authorized to delve into church structure, which I think you mentioned church structure early on. So why is that? Why is it appropriate for a secular court to essentially evaluate the structure of a court and the authority of the actors within that structure?
The court does have the authority to do that. And the case law is clear that the court has the authority to do that. Our Supreme Court has indicated that the court has the authority to do that. Not only the authority, but the obligation to do that in a setting like this. The problem with this case is that they never made that determination. The court never made that determination. Not only that, but it's stated on the record and in his printed order that I'm not going to get into it. I'm not going to make a determination. And what you got to remember, Judge, the authority issue is a secular issue. A secular issue that can be decided by the court without having to go into religious belief, doctrine, or the appropriateness of canon law or anything else. It's something that the courts are designed to deal with. This is a secular issue.
You do cite, though both parties cited canon law in their arguments as to the authority of the pastor in this case in terms of the employment agreement, correct?
Yes, Your Honor.
So how would we be applying anything other than canon law and reaching that decision? Or how would any court?
There's nothing that says you cannot apply canon law. I've cited to the court in my briefs numerous cases that have referred to canon law. Canon law in a hierarchical church is the essence of the organization, the essence of which they live by, just like we live by the Constitution and so on. So we look at it. But there's no harm in looking at it. That's what the problem is. The problem is that some courts and the court below has said, I'm not even going to look at this. I'm going to go ahead and just take the diocese word for it, that there's no authority. So they're bringing up an issue that's really black and white and really is easily determined and there's no doubt about it. It's like the distinction, it's along the same lines of the separate and distinct. They claim that they're not separate and distinct. They claim they're one organization, that the parish is not a corporate soul. Well, those are secular issues, whether it's a corporate soul, and then they make it admission that they publicize to the world that they're separate and distinct based on canon law. We go back to canon law. It is not a fault. It is not a impediment to go back to canon law when you're looking at these type of church organization that are regulated by canon law. That doesn't mean we're going to interpret the canon law. That doesn't mean we're going to change the canon law. We're not doing that. We're just asking the courts to go ahead and look at the canon law. And I've got an expert that I submitted.
I guess I'm not understanding fully your argument that we would look at canon law, but we would not interpret canon law. Right. So let me walk it back. So you would agree that the issue here is that the issue of whether the pastor had the authority to enter into the employment contract, right?
Right.
What legal principle or canonical law would you apply in answering that question?
You go to the canon laws that give the pastor almost absolute control over the.
So we would be interpreting canon law and determining the authority of the pastor.
Judge, it would be looking at canon law. And yes, sometimes the courts will have to make a decision. Mostly if Ms. Land then presents an argument that in fact the parish doesn't have the authority, then you've got to make a decision. But that's what courts do every day of the week. They make decisions. They make decisions based on
certainly, and based on laws passed by the legislature or executive orders or whatever the case may be. In this case, we would be called on to interpret and to apply canon law, right?
Only if authority is an issue and only to look at it. But
authority, I think we've all established though that authority is in fact an issue and the primary issue and what the trial court honed in on.
But it's got to be decided based on secular law, not canon law. Canon law we can look at where it says the parish is a juridic person. The pastor is not a juridic person. The pastor is in charge and appointed by the bishop to regulate that juridic person. That juridic person, the definition of juridic person is exactly what a corporate soul is. It is a position appointed by the bishop that in fact is in perpetuity. The only thing that changes is the pastor. So the authority, I kind of lost my train of thought, to be honest with you.
Well, let me ask you this. So the applicant has submitted a supplemental authority of Our Lady of Guadalupe, which part of the court's opinion states that the independence of religious institutions in matters of faith and doctrine is closely linked to independence in what we have termed a matter of church government, explaining that neutral principles only applies to the extent that it does not butt up into church autonomy.
Yeah.
So can you respond to how applying that and taking that as U.S. Supreme Court precedent, how we would not determine that this is a matter of church government and we would have to dip our toes into church autonomy?
Because there's nothing religious about the authority. There's nothing doctrine-wise by the authority. You're not getting into the religious beliefs. You're not restricting religion. You're not doing anything along those lines. It's confusing, missing, matching what these cases have all said. The bottom line is that you can look to the structure of the church when you're making a determination whether somebody has authority. That's clear. You can do that. Malik has said that. The Florida Supreme Court has said that, and has said that you've got to make that determination even if it's difficult. And for a court to then say, I have to go ahead and comply with the Florida Supreme Court and make the determination, but I'm not going to delve into the issue of apparent authority or the organizational structure of a church, is contrary to Malik. It's contrary to our Florida Supreme Court decision that says you got to make that determination. And you cannot start throwing things on the wall saying religious belief and doctrine. Show me one religious belief involved in the apparent authority argument. Just one. Show me one doctrine involved in that, other than we get scared when we refer to canon laws. Canon law, we got to talk to canon law, therefore that's religious.
It's not a matter of being scared about interpreting canon law. It's a matter of applying and interpreting canon law, and not a hesitation in whether it's appropriate, but the bounds of legislative and judicial power as it applies to churches, isn't it?
Right. Let's make it clear. We're not going to ask the court to interpret canon law. We're going to ask the court to read the canon law, to read it. It's in black and white. We can look at it. Who's got authority? Now, they can go ahead and say in the website that they're two distinct entities and then change their mind in court to try to get this kind of immunity from involvement in this case and get themselves out. They're basically toying up this issue, which is not really an issue, Judge. It is not an issue. The authority of the parish and the pastors are clear and unequivocal, but they're kicking this notion up so that then we are seeming to get into church law and interpretation and so on. The reason I hired an expert from Rome, from the Vatican, who's knowledgeable in this area, is just because they brought up this improper and incorrect notion that there's some dispute as to what the pastor and the parish relationship with respect to the diocese. We're trying to correct that. We would not have brought up that expert. I would not have hired this man if in fact they had not brought up this false issue of what the authority of the parish is. And
so you think the relationship of the pastor to the diocese is an issue that is secular?
Yes, not only that, I believe further, they brought up the issue of privity, that's secular. Corporate soul, whether we're going to get into corporate soul, that's secular. And whether the priest has the authority, that's all secular. And
are you relying on a specific case for that proposition, that these are secular determinations, a relationship between a pastor?
Well, I am relying on the Florida Supreme Court and Malik, of course. But with respect to whether corporate soul is a secular issue, I really don't have any case because it's irrelevant to this proceeding at this stage, but it was mentioned.
And of course, Malachi's only holding, which was very narrowly and clearly stated, was that a plaintiff's claim founded on religious institutions alleged negligence arising from essentially sexual battery is not precluded. So what portion of Malachi do you contend controls this case?
that the site that I made in my initial brief, which basically requires the court to make the determination when alluding to something like a breach of contract, a secular breach of contract case, which is exactly what we have. I think even the district court, I think even brought it in more detail with respect to the fact that you can get into it. And then you've got Justice Rehnquist, who very clearly says that people are wrong when they say you can't get into the structure. And and he didn't say anything about necessarily canon law, but to look at the structure, you have to look at the canon law. The canon law dictates the structure. You can't have one without the other. So there is no impediment for the court to get into, by getting into canon law, to avoid handling this case. This case is a make-believe case on a make-believe issue. The authority of a pastor, which is really, really clear in the Catholic Church, is really, really clear in the canon law. And they're just kicking it up there because that's their second argument, because their first argument was that there was something going on between Father Brown and the diocese that were contending, which is not going to be an issue that's going to be raised in this appeal. The church is not going to raise that issue again. They're just raising it now to try to kick mud up, but it's not going to be. Plus, it's totally irrelevant. It has nothing to do with the issue at hand. The issue at hand is there a contract? Yes. Was there a breach of the contract? Yes. Is there damages? Yes. That's it. Those are the issues. And I initially brought this matter knowing what I know about the Catholic faith and the Catholic organization against St. Joseph and his pastor, who's now a different pastor. The diocese, again, I've been reacting. So the diocese reacts, I react to it, and then I bring in the diocese, since they say the diocese is the one that controls it all. I submit to the court that actually when somebody takes a look at it and really dwells into it, that you'll find that the parish is a corporate soul, like it's been incorporated in other states, a parish as a corporate soul in other states where they have the statutory framework to incorporate corporate soul, which we don't do in Florida. In Florida, we don't incorporate corporate soul. We go by the common law and we figure out whether something is or is not. Well, this court ought to figure out whether the parish is a corporate soul. And that's a secular issue. Privity, that's a secular issue. And with respect to apparent authority or actual authority, those are secular issues. And we cannot be thrown off the track by them then challenging something that is well known in the Catholic faith. And that is.
You're into your rebuttal time if you want to save it.
Yes, Your Honor, I will. And Judge Sasso, if you have any other questions, I'll take my time with you.
No, you can reserve for rebuttal.
Thank you, ma'am.
Mm-hmm.
All right, counsel.
May it please the court. This case is a clear case for application of the ecclesiastical abstention doctrine. We ask this court to affirm the lower court decision for 3 reasons. First, each party has provided its own authority on interpreting canon law in support of its position.
Well, can you respond to the appellant's arguments that we would refer to canon law only to determine the pastor's role, and from there we would apply secular and neutral principles as to whether that does in fact create privity or agency or whatever the case may be?
Sure, Your Honor. Actually, that's not the case. Here, the court would be looking to determine who has authority between the bishop and the pastor to enter into the employment agreement, which both parties have demonstrated it's based on canon law, whereas this case, each party has a different interpretation as to how canon law treats the powers and authorities as it relates to the bishop and the parish pastor.
So let me interrupt for a second. Could the court decide that issue by looking at the employee handbook, the diocese employee handbook?
Yes, so Your Honor, the court, we have provided a handbook provision that shows that the bishop's policy is that the parish pastor did not have authority to enter into employment agreements. However, in order for Napolitano's claim and contract to be enforced, this court would have to disregard that policy, and Napolitano asserts that this court should disregard that policy and instead look to canon law and their interpretation of canon law to grant the parish pastor authority and disregard the diocese's interpretation of canon law that says the interpretation is that the bishop can control the employment policies. And that is where it fits within the ecclesiastical abstention doctrine that says the courts cannot make a determination when you have two competing interpretations of doctrine.
Okay,
Whereas,
let me ask you this. Does the diocese employee handbook conflict with any canon law?
in the opinion of the diocese, it does not.
Any church governance?
Your Honor, the diocese asserts that the bishop's policies are in line with canon law.
Okay, now, does the diocese employee handbook conflict with any church policies or politics?
I don't quite understand your question. In any church politics?
Yes, policies. Does the handbook conflict with any church policies or polity?
Polity. So, Your Honor, the diocese asserts that its handbook is in support, it derives from the authority, the ecclesiastical authorities granted to the bishop in his powers and authority to govern the pastors and the parishes within the diocese.
Correct.
And so it is in line with that.
No conflict. And my last question is, does this employee handbook conflict with any church doctrines?
The diocese asserts that it does not, whereas Napolitano asserts it does. And that is where the ecclesiastical issue arises in this case. In order to enforce this contract against the diocese, the court would have to make a determination as to whose interpretation of canon law is correct. Is it the diocese's interpretation that says that the authority is within the bishop and his policies to create such employment policies and to control the employment? Or is it the Napolitano's assertion and her interpretation that opposing counsel has been explaining to this court this morning that no, their position is that no, they think canon law should be interpreted a different way. And if you look at the sister courts in Mammon, which is coming out of the 3rd District Court of Appeal. In that case, you had a civil contract between two parties, and it was for burial services. And because each party had its own interpretation of what was proper Jewish burial and customs and traditions, the court said, we can't make a determination in this case as to which party is correct on their interpretation of Jewish customs and traditions, and therefore the ecclesiastical abstention doctrine applied.
Follow up on Judge McIntosh's question. If a court determined the employment handbook resolved this dispute from a subject matter jurisdiction standpoint, is that something that a court would be able to apply, just a straightforward application of an employment handbook?
Well, the issue here, though, is that the employment contract says that the parish pastor did not have authority to enter into an employment agreement. And so fundamentally, the court would have to be making a determination as to whether or not that individual, the parish pastor, had authority. And so you would have to be questioning whether that would be one piece of question.
Excuse me, but we would only have to make that decision if there was a controversy, correct? Okay, so we have an employee handbook. Why could the trial court not look at the plain language in the employee handbook to resolve the motion to dismiss?
Because plaintiffs count, because Napolitano has placed the canon law at issue. Napolitano has stated in the response to the motion to dismiss that no court, the issue is canon law, because canon law in the court provides in the ecclesiastical matters of the Catholic Church says that this authority is granted in the parish pastor to enter into this contract. So it has been the religious and ecclesiastical matters are based fundamentally on who has power and authority within the parish pastor and the bishop within the diocese. And that policy derives from that fundamental question. And the fact that we've got two different authorities with their various positions and interpretations of canon law demonstrates that this court can't answer that question without going to what's behind that policy,
But
which is the fundamental government.
Excuse me, I'm sorry.
Sorry.
Isn't that what your clients, you are arguing that Ms. Napolitano's claims rely on an interpretation of canon law and Catholic policy, correct? You're the one taking that. Your client takes that position.
The position of our client is both sides are taking that position.
No,
Because-
ma'am. We just heard him argue it's a secular issue. It's a 100% secular issue. You may have to read some things, but there's no interpretation. There's no controversy. It's a secular issue.
So let's look at Jones v. Wolf, which is a U.S. Supreme Court decision. And it says, if you have a church document and you can look at it straight up and decide the answer to the case, the answer to the question, looking at that document without referring to ecclesiastical matters to decide whether or not to decide how to apply the document or how to interpret the document, then you could decide on neutral principles. But the minute you have to decide to rely on ecclesiastical matters to come to your decision, then you've got a problem. Here, the fundamental question in a hierarchical church as to who has authority to control the employment at the parish, whether it be the bishop or the parish pastor, is fundamentally an ecclesiastical matter.
Right. And you just told us that the diocese employee handbook does not conflict with any ecclesiastical matters. There's no conflict.
But the case of whether there is authority is going to go beyond just the handbook. It is a fundamental question as to who has authority to enter into an employment contract. So if this court were to say, make a determination that Napolitano's contract should be enforced against the diocese, it would have to destroy the diocese's policies on who had authority to enter into employment contracts. But in addition, it would also be going against the ecclesiastical powers granted to the bishop, that and it would be telling the interfering with the diocese's ability to govern its parishes and pastors. And so the determination and resolution of this case, regardless of whether the court decides to go on the handbook provision and just look at the four corners of the handbook, or to fundamentally go against it and rule that the parish pastor had authority and ignore that handbook, then it would be making a determination that the diocese's own determinations as to who has authority within its government is going to be decided by the court. And that, when there's a dispute as to such things, so fundamental into church government as authority between the bishop and the pastor, that is where the courts have said the ecclesiastical abstention doctrine is applied.
Ms. Lant, let me ask you a question. Are you familiar with the case of Bishop Favarola versus Sidaway?
No, Your Honor.
Okay, well, basically the facts were relatively simple. The plaintiff entered into a settlement agreement with the church that the plaintiff subsequently felt the church had breached. And the question became whether or not the person on behalf of the church who entered into the agreement had the authority. And the same issues that we have here were raised, whether this required us to examine an issue of authority. And the court said there, the underlying suit will not require the circuit court to resolve any ecclesiastical dispute of religious doctrine or governance. Here, though the questions regarding the scope of the agent's authority may require some examination of church law, this in no way interferes with the archdiocese's religious autonomy over its internal affairs. So if we look at, the ecclesiastical doctrine is based upon this idea of we don't want to get excessively entangled. how does this dispute get us excessively entangled if it's simply looking at a matter of agency?
Because this case is fundamentally a question as to who is right and who is wrong between the bishop and the pastor as to authority. And so it is not a basic question of authority.
But aren't we assuming that the church, like any organization, there are rules and there are rules that don't get followed? And there's a lot of things in an employee handbook that sound good on paper, but frequently don't get followed. I don't know what the evidence would ultimately show in this case. But if the evidence was from the pastor, hey, I asked the bishop and the bishop said, sure, she's a great employee, go ahead. Why does that involve us in internal church matters? Why isn't that the same thing as in your law firm? If your employee handbook says one thing and you ask the managing partner and he says, sure, go ahead, or she says, great, go ahead.
Because I think this contract is a contract that deals with church government. And if you look at the contract, it's a contract that specifically was not authorized by the diocese, a contract that has a specific provision that says it supersedes all of the diocese's policies and procedures. It's a contract that specifically violates the bishop's policies on who has authority to enter into the employment agreement. It's a contract that provides the Ms. Napolitano years of continued employment and frustration of the bishop's appointment and merging of two parishes and his new parish pastor's ability to control those parishes.
Let me ask
employment in those parishes. And go ahead.
Come back and focus. And again, I understand that you haven't read that case, that Favarola case, and for your reference, it's 995 Southern 2nd at 1133. But basically, the court there said is the fact that we have to look at church law doesn't interfere with the church's autonomy or internal affairs. So how do you distinguish that holding from the facts that we have?
Because we're not looking at being asked to look at just church law. The court here is being asked to fundamentally determine a dispute about that interpretation of church law. And if you look at the Florida sister courts, when confronted with two different interpretations of church law, that is where the ecclesiastical abstention doctrine applied.
Let me ask this. So, and that kind of goes to the actual authority issue, but appellants have also pointed out that there could be an apparent authority issue here, which might be decided on purely secular neutral issues. So what is your response to putting actual authority aside, why the argument of apparent authority presents an issue when it comes to the court's jurisdiction? Because
the impact on the religious freedom of the church is the same. And that's because even by resolving the case, the ecclesiastical abstention doctrine would be violated. And that's because enforcing this contract against the diocese would violate the bishop's policies on who had authority to enter into an employment contract. Enforcing this contract against the diocese would interfere and contradict the ecclesiastical powers granted to the bishop to control the pastors in the parishes. Enforcing the contract against the diocese would also interfere with the diocese's ability to govern its parishes and pastors. And the court in Our Lady of Guadalupe made it quite clear that church government is an ecclesiastical matter. And as I described the contract to you a moment ago, this is a contract that deals with church government. And enforcing that contract, the court, whether it rely, Judge McIntosh, on that policy, or whether it rely on some other matter, if it enforces it, it is decided not to rely on that policy and instead override that policy and tell the bishop and the diocese that you don't have the ability to decide who has authority to enter into this employment contract. And we do have the ability to go in and say, no, this is not, the court is going to tell the diocese who has the power and authority between the bishop and the parish pastor. And as both parties have provided dueling authorities providing their interpretation over who has authority based on canon law, demonstrating that there's a fundamental issue as to the interpretation of church law. And that's where it is differing from these cases. And though Justice Orfinger, even though I haven't read that case, I imagine, and I would assume there wasn't a dispute as to the church law it was reviewing. It's when you have a dispute as to the church law, there's a problem.
So if canon law said the priest shall not do X, whatever X is, canon laws don't do X. But the bishop says in a policy of the church, the bishop says it's okay to do X. We can't look at that if that involves some court claim, for example. If X was don't do something that's going to be harmful, but the bishop's policy is it's okay to do X under certain circumstances, and somebody claims a tort, we can't look at something like that?
Well, tort law has a different application. So if you look at Maliki, that's the Florida Supreme Court case. They did say that we're going to look at things a little differently when we have a tort case. Whereas this falls into more in line with some of your other sister districts, where you're not looking at a tort case, but you're looking at an interpretation of two differing interpretations of church doctrine. So if we look at Flynn versus Estevez, that's coming out of the first DCA. There's a case where you have a student at a Catholic church or at a Catholic school, and the student was not vaccinated. The school said we have a policy that everyone needed to be vaccinated. And the court said that the issue in this case is that both parties are showing their own opinion of their interpretation of Catholic doctrine on whether it supports or doesn't support vaccinations in schools. And the court said, because we have this dispute, we cannot make a determination, and the ecclesiastical abstention doctrine applies. And that's where this case fits in that line of cases. I see my time is almost up. I believe I answered your question. I do ask of this court, per curiam affirm the lower court decision. Thank you.
Thank you, counsel.
Thank you.
All right, Mr. Benitez, you've got a little over 3.5 minutes.
Yes, Your Honor. Your Honor, this is a secular issue. All the issues that we've talked about are secular. With respect to having to look at canon law, it's only going to be necessary if, in fact, the diocese continues to take them out of context or take a position.
How do you distinguish this case from the case that was mentioned in the brief that counsel mentioned here today, the Mammon case, over differing views on Jewish burial customs?
Because, Judge, that was a religious issue. That's religious doctrine.
Is it a religious issue?
Yeah.
A hierarchical church as to what authority, I mean, I assume it goes from the Pope to the Cardinal to the Bishop to the parish priest, but how that authority then gets divvied up and enforced, isn't that a matter of internal church governance?
Not in this case, Your Honor. In this case, we've got a contract that was entered by the pastor. Those are two facts that are uncontradicted. And now the question is, what in their defense, apparently they haven't filed responsive pleadings, but their defense is going to be that he didn't have authority to enter into that contract. And that's a secular issue. That's something that can be determined by the court without getting into religious belief, religious doctrine, or anything having to do with religion at all. This is a contract dispute. If they bring up the handbook is there. We're not going to contest that it doesn't exist. It exists. It's going to be what effect that has with respect to Father Brown. That's none of our issue. Father Brown and the church can handle that through the Vatican with the proper procedures with respect to anything he might have stepped out of line. But in this case, all we got to look at is, in fact, was there a contract? Was there a breach? And was there damages?
Well, but there can't be a contract if it's entered into by a party that doesn't have authority, either actual or apparent.
Correct, Your Honor. And in this case,
we don't really know at this point anything about apparent authority. I mean, they've set forth documents. I mean, I think it's fair to say that I didn't see, at least in the canon law citations that were there, that there wasn't anything that was quite on point, but the church employee manual or the handbook seemed to be pretty clear. So, I mean, as part of your argument, to be a contract, it's got to be entered into by somebody with authority or apparent authority. Don't you agree?
Yes, Your Honor, I do agree, and I believe.
How do we address at least the actual authority if there is a dispute, rightly or wrongly, even if the bishop is wrong, if his position is, look, I'm the bishop and I say you can't do this, even if, some higher authority in the church might disagree, as far as we're concerned, why isn't that the end of the discussion?
Because that's not the issue, Judge. The issue of whether Father Brown had the authority or not between the bishop and Father Brown is totally separate. It's totally irrelevant in this case. In this case, is what Napolitano did with Father Brown. And I know that that's more apparent authority.
Well, but that also
authority, but
doesn't that also get us in that argument might hold some water if the local church is in fact a separate legal entity, that they would have the authority to enter into a contract. But I mean, maybe I'm wrong, but I always thought the whole idea of a corporation sole, as far as the church goes, was that the bishop was essentially the church. Answer that question, and then we'll go on, and then you'll be done.
Yes, Your Honor. Your Honor, the church consists of the Pope. It starts from the Pope. It goes, like you said, to cardinals, to bishops, to pastor, and so on. There are corporate souls within the Catholic Church. In some, like I mentioned before, in some states, corporate souls can be incorporated or formally recognized. In the state of Florida, they cannot be. Some of those states have parishes as corporate soul. And that's come up at numerous issues with respect to these sexual molestation cases where the church has taken the position in one case that they are one unit and the bishop controls the parish.
All right, counsel, we're going to go ahead and wrap it up. Thank you. We've given you a little extra time, but that'll conclude this argument for today. Thank you both for your argument, and we'll be in recess.